From KPRC2, this is Houston Newsmakers with Cambrell Marshall.
Well, it has been an historic past couple of weeks with the impeachment trial of Texas Attorney General Ken Paxton. The state senators, as the jurors, have been listening to the House prosecutors and the defense presenting their cases. As this program is being taped, the outcome is not clear, so we will focus on the legal process. And joining me to break down what we've seen the past couple of weeks, what went right and perhaps what not so right, KPRC2 legal analyst Brian Wice. Always good to see you, sir. I want to first let our viewers know that you are one of the two special prosecutors in the three pending felony securities fraud cases against Mr. Paxton. Those cases are not in any way associated with these articles of impeachment.
Apples and oranges.
So it gives us a chance to kind of talk about this. As we watch the case unfold, who do you think were the most important witnesses in this case for the prosecution?
You know, there's a saying in Hollywood, there are no small roles, only small actors. I think everybody in their own way was consequential. But I think if we had to narrow the field, so to speak, I think that Mark Penley, General Paxton's former chief of criminal justice, I think cast a long shadow. I think that Brandon Kemick, the young lawyer who was hired as an outside counsel by General Paxton, also figured prominently. I think that at the end of the day, though, some of our viewers may be wondering who it was that didn't testify. I know that there was an anticipation of monumental proportion about General Paxton's alleged mistress, Lee Olson. And that, to me, was one of the potential game changers, where she was declared, wait for it, air quotes, unavailable to testify.
And I'm going to talk about that a little bit more, but I know that also during the process, I noticed that the Paxton team seemed quite aggressive in their cross-examination. Was that something that they had to employ in this case?
You know, everybody has their own styles. You have to be yourself because everybody else is taken. And when I think of the defense team, you've got Tony Busby, obviously someone who is Rusty Hardin, love to say, majored in the art of screaming cross-examination. Mitch Little from Collin County, who believes that cross-examination is about examining crossly. And then Dan Cogdill, who I think is the LeBron James of cross-examination. On the House manager side, I think we saw a hidden superstar, Erin Epley, who, spoiler alert, I've known since she was a young Harris County assistant DA and then went to work for the U.S. Attorney's Office here. She clearly distinguished herself as one of the hidden gems in the manager's case. I wish they had let her done more earlier.
So you mentioned about Lee Olson earlier. I want to talk about that a little bit more here. Much was made about this, quote, alleged mistress. She showed up at the Capitol on Wednesday, seemed ready to testify, and then didn't. What was that all about? And how does that not seem fishy? I mean, it just seems really fishy to the layman.
Well, Laura Lee Olson came dressed to kill, but not dressed to testify, as it turned out. She's an important figure in this narrative because she is part of the Let's Connect the Dots and the alleged bribery scheme between General Paxton, Nate Paul, his campaign donor, who is alleged to have been a co-conspirator with General Paxton in a number of these counts of impeachment. But there are a number of ways that you can be declared unavailable to testify under the rules of evidence.
Which is what Lieutenant Governor Patrick said. He said she's unavailable.
Exactly. One is that you're deceased. Two is that if you're incompetent to testify. Three, if you're outside the jurisdiction of the court. But fourth, if you invoke a privilege. And there are a number of different privileges. Priest, penitent, doctor, patient, attorney, client. And in this case, she invoked, according to the people close to the matter, her Fifth Amendment right not to testify. I believe, reasonably, that's a result of an ongoing federal investigation at which she may or may not have testified in front of a federal grand jury in San Antonio. Is it fishy? I think that the law provides for that privilege, but I really think that if this had not been an impeachment as opposed to a civil trial, the jury would have been able to hear the fact that she came in and she took the Fifth and she had something to hide.
Well, now, the senators were never told that. They just said she's unavailable. These are senators. They know what's going on. They're not like a normal jury trial where they don't know anything about that. You think they probably know that she took the Fifth?
Oh, I think there are a number of jurors, if not most of them. Look, one stands out in particular, Joan Huffman, one of the most powerful, erudite members of the Senate. I've known her since she was a young prosecutor and then a terrific trial judge. I'm going to go out on a limb and say that Joan Huffman at least knew that Lee Olson came in and took the fifth.
Okay, I want to call your attention to something that happened at the end of the prosecution's case, and it's the way it ended. It just seemed strange to me. I want to get your take. Watch.
Your Honor, at this time, the House of Managers rest. House Manager.
He just rested without a cross-exam. I can recall the witness, though. I'm fine with that. We'll recall this man. We will accept the rest.
Yes.
And that's how it works.
He's certainly right. I mean, I want to concede he's absolutely right. I apologize. I think he is entitled to his day in court. Thank you.
So he has given you your cross-examination, if I'm understanding, Mr. Hardin?
Certainly.
Your Honor, we have some motion practice we'd like to take up with the court today.
All right.
Now, is he waiving cross or?
That I would recall this witness in our case in chief. If there is a case in chief needed from us, I'd like to do some motion practice today.
But here's the problem. I messed up and shouldn't have rested until he finished his cross.
So, big mess up or minor in the scheme of things?
Cam, in the words of noted legal sage William Shakespeare, much ado about nothing.
Okay.
The optics were odd. Rusty would have been the first to say that he had a self-professed senior moment, but I believe on some level it ultimately helped the managers because as it turned out, the defense never called Blake Brickman back to the stand. Make no mistake, Blake Brickman, one of the former deputy chiefs in the AG's office, hurt the AG's case, and he was never subject to cross-examination. Did Rusty have that in mind when he had his professed senior moment? No. But much ado about nothing.
Okay. As a trial, legal trial, we watched this. It's obviously historic. Finest hour or forgettable exercise, you think, in terms of the legalities of what's going on that we saw in the last couple of weeks?
You know what? That's a great question because as we sit here today with the result yet unknown, from 35,000 feet, if I believe that the Senate was a typical rational criminal jury trial, I think there's more than ample evidence to convict on more than one count. But these aren't, with all due respect, rational jurors. These are senators. And for those of us like you and I who didn't sleep through government class, we know not to be cynical that no politician has ever done anything, ever acted in any manner except in his or her political best interest. When you view it through that lens, I don't have a really good feeling about what's likely to happen in terms of convicting on one or more counts.
All right. Well, we appreciate that. As we said, as we're taping this now, we don't know the answer, but we soon will know. But thank you, Brian Wice, our legal analyst, for coming in and always giving us an extra lesson for those of us who didn't sleep through government class. Thank you, Brian.